Much progress has been made in reducing racial discrimination in the workplace since the passage of Title VII. But let's take a look at the prominence and problems of race and color discrimination. Discrimination based on skin color, also known as colorism or shadeism, is a form of prejudice or discrimination in which people are treated differently on the basis of social meanings attached to skin color. However, in 2013, the EEOC reported that the number of race-based harassment charge filings had increased from 5,783 in 1997 to 9,286 in 2015. Also, in 2015, the EEOC received 31,207 charges of race-based discrimination and resolved 31,782 cases. Cases carry over from one year to the next, with monetary benefits of $88.4 million for plaintiffs. The last figure does not include monetary benefits included in litigation. Under certain conditions, plaintiffs can file charges in court but may receive additional monetary benefits. Employers violate Title VII when they use race itself or race-related characteristics and conditions to make employment decisions, tolerate the harassment of employees because of their race or color, segregate or classify employees based on race or color, or collect pre-employment information about race in such a way that it's available to those making hiring decisions. The following are examples of race and color discrimination by employers in violation of Title VII. Using race or race-related characteristics and conditions to make employment decisions. A no-beard policy may discriminate against African American men because they're predisposed to a medical condition that makes shaving difficult. Selecting only light-skinned employees because they best fit the preferred company image is discrimination on the basis of skin color. Tolerating the harassment of employees because of their race or color. Permitting racial slurs and racist graffiti creates a hostile work environment. Making derogatory remarks about an employee's skin color and then firing the employee for complaining to management is a violation of Title VII. Segregating or classifying employees based on race or color. Assigning racial groups to work only in areas where the customer base is predominantly of the same racial group is discriminatory. Assigning employees to a certain racial group exclusively to work in certain jobs in the company is considered discrimination. Collecting pre-employment information about race in such a way that it's available to those making hiring decisions. Asking for information that would identify race as part of the pre-employment process is not permissible. Coding applications or resumes so the interviewer knows the race of applicants is another example of illegally classifying employees. Dismissing an employee because of his or her association with someone of a different race. Learning that an employee has a biracial child and using that information to discriminate against him in the terms of the privileges of his employment is discrimination. Finding out an employee is part of an organization that supports minority rights and using that information against her in the employment process is also a violation of the law. Title VII of the Civil Rights Act of 1964 protects individuals against employment discrimination on the basis of race and color.